Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi and a very good morning to all. Excellencies, honorable delegates, distinguished guests, ladies and gentlemen. First and foremost, let me thank the joint organizers, namely the Asian Institute of Alternative Dispute Resolution, or AIADR, the China ASEAN Legal Cooperative Center, or the CALCC, Hainan International Arbitration Court, or HIAC, and the Asian Law Students Association, ALSA, for inviting me to this forum. It is my great pleasure and privilege to deliver the keynote address for this forum. I also thank the supporting organizations, the Asia Pacific Corporate Council Alliance, or the APCCA, the Thailand Arbitration Center, or THAC, the Nanning Arbitration Commission, or NNZC, Legal Pras Sdn Bhd, and Malaysian Mediation Center, or MMC, for the endorsement on the event. On behalf of the Dubai International Financial Center Courts, or the DIFC Courts, of which I'm the Chief Justice, I would like to extend my warmest welcome to all present at the opening of the COVID-19 Asian Mediation Forum 2020. Special mention needs to be given to the honorary guest, Secretary General of the Asian African Legal Consultative Organization, or AALCO, His Excellency Professor Kennedy Gastorn, for his wonderful speech exploring the Asian-African perspective of mediation and the role of institutional mechanism in dispute prevention and settlement. Ladies and gentlemen, I was moved by the launch of the AIADR Mediation Rules 2020 amid the pandemic of COVID-19. My cordial wishes for the huge success of the rules. I also express my warm welcome to the theme of the Forum on COVID-19 Asian Mediation Forum 2020. As early as August 2010, I recognized the importance of mediation in resolving disputes. As an attempt to resolve backlog of cases, besides assisting disputing parties in achieving amicable settlement, I gave direction to the Malaysian judiciary as the then Chief Justice of Malaysia via Practice Direction on Mediation number 5 of 2010, encouraging parties to reach an amicable settlement by way of mediation without going for trial. The direction on the use of the mediation in resolving disputes was issued even before the parliamentary enactment of the Malaysian Mediation Act 2012. It was aimed at facilitating the settlement of disputes before the court. As the Chief Justice of the Dubai International Financial Center, I am doing the same. I'm encouraging parties appearing before the courts to find a solution to mediate their dispute. With the blessing of His Highness Sheikh Mohammed bin Rashid Al Maktoum, Vice President and Prime Minister of the UAE and the ruler of Dubai, the Dubai International Financial Center is encouraging the use of mediation in settlement of disputes brought before the courts. As the costs related to dispute resolution have continued to increase over the years, there has been corresponding rise in more formalized mediation processes in the Middle East. Courts in the Middle East are increasingly likely to encourage and even require mediation as an important step in the dispute resolution process. This is evidenced by the DIFC Court Small Claims Tribunal, or the SCT, which includes a required mediation and conciliation phase for all cases. In recent years, the Small Claims Tribunal has recorded 80% of such cases resolved in the mediation stage without having the need to progress to hearing. And in 2019, the DIFC courts and Dubai Healthcare City Authority signed an agreement that saw Dubai's leading healthcare-free zone become the first government entity to utilize the services of the DIFC court's newly created Special Complaints Referral Center, the SCRC. The agreement established a framework for DHCA to benefit from the specialized expertise derived from the mediation mechanisms available through the Small Claims Tribunal model. The newly formed Special Complaints Referral Center is also available to all public and private sector entities wishing to avail of a more user-friendly, mediation-oriented form of dispute resolution. In early 2018, the DIFC courts also issued the Registrar's Direction No. 1 of 2018, which provides for alternative dispute resolution. In December 2020, the DIFC courts will release a practical guidance note enabling the court to exercise a general discretion to refer parties to mandatory mediation at any time. Such a referral shall have the effect of staying the proceedings until the end of the mandatory process. Now, going back to what had happened in Malaysia, the benefit of mediation is threefold. It is accepted by the parties, expeditious, and it is final. I still remember the then-led modes of mediation were either judge-led mediation or by a mediator agreeable by both parties. In Malaysia, mediation at the lower courts were very successful. Between March and September 2010, 27% of the cases had been successfully mediated out of court-assisted mediation, 30% were unsuccessful, and 43% were still pending. In June 2016, the additional mode of institutional mediation under the auspices of the Kuala Lumpur Regional Centre for Arbitration was further introduced by Practice Direction No. 4 of 2016. At this juncture, I respectfully think the introduction of the AIADR Mediation Rules 2020 is best complement to the mediation by agreement where parties may agree to be bound by the AIADR Code of Conduct Rules and the appointment of the mediator by AIADR. The lack of monetary limitation and jurisdictional constraint under the AIADR mediation rules could provide good alternative to the public in resorting to neutral and impartial arrangements for the mediation processes and procedure on voluntary basis. Now, worthy to mention that in June 2016, the Mediation Division of the Federal Court of Malaysia was established, and is currently placed under the supervision of the Chief Registrar of the Federal Court of Malaysia. The role and functions of the Mediation Division are: 1. To establish mediation center at every state court. 2. To provide training, mentoring, and consultation services for the local state mediation center. 3. To establish policies pertaining to mediation for mediation center. 4. Regulating the operation of mediation center. And 5. As a center for data and information collection relating to mediation center throughout Malaysia. Ladies and gentlemen, since the launch of the very first local state mediation center of Kuala Lumpur Mediation Center in 2011, there have been 8 additional court annex mediation center established in different states within Malaysia. That is in Shah Alam, Johor Bahru, Penang, Ipoh, Seremban, Kuantan, Kuching, and Kota Kinabalu. On top of establishing local mediation centers, the Mediation Division of the Federal Court also focuses on the function of capacity building by way of training, mentoring, and consultation services to the local mediation centers. Capacity building is crucial to the success of Mediation Forum. Institutions such as AIADR could play an important part as a knowledge database in providing affordable and accessible courses and trainings to the public and prospective mediators outside the purview of local mediation center. At the time of writing this speech, I was made to understand that the followings have been in place by the AIADR for public access, and the AIADR training courses on mediation have also been lined up for those who are keen on pursuing domestically or internationally. 1. There is the AIADR mediation rules, the AIADR Code of Conduct for Mediators, AIADR Frequently Asked Questions on Mediation, AIADR Sample Mediators Disclosure Statement, AIADR Sample Form of Agreement to Mediate, AIADR Template for Settlement Agreement, AIADR Guidance Notes on Cost and Payment, AIADR Guidance Notes on Venue and Virtual Proceedings Managed Services, AIADR Checklist on Virtual Proceedings Best Practices. The initiative on capacity building by AIADR is most welcome, and I hope it could bridge the gap in lack of comprehension amongst public regarding the application and effectiveness of mediation as a viable resort of alternative dispute resolution. This is especially significant with the shift in focus on non-adversarial measures of resolving disputes during these difficult times. Ladies and gentlemen, pursuant to the enactment of the Temporary Measures for Reducing the Impact of Coronavirus Disease 2019, COVID-19 Act of 2020, in short, COVID-19 Act, the Malaysian government had also established the COVID-19 Mediation Center, or the PMC-19, to assist the public in resolving their dispute in respect of any inability to perform any contractual obligation arising from categories of contracts specified in the Schedule See Section 7 of the COVID Act. The objectives of the PMC 19 are to assist parties in resolving disputes via mediation without involving litigation process, and to assist those from B40 and M40 categories. By the way, B40 and M40 are classification of earners, people who earn below 40% and mid 40% categories, and micro, small, and medium enterprises, or SME, to resolve disputes by subsidizing the cost of mediation. It focuses on contractual disputes arising from the implementation of the Movement Control Order in Malaysia to curb the spread of COVID-19 pandemic and assist in resolving disputes not exceeding 300,000 ringgit. That is about just less than 100,000 USD. It also aims at providing mediation services at a reasonable rate. The coming into force of the COVID-19 Act and establishment of Government Mediation Center have drawn much attention. A look into the Act and role of PMC 19 would indicate that the resort to PMC 19 is with necessary impediments such as monetary limitation of dispute sum not exceeding 300,000 ringgit, fulfillment of eligibility criteria for PMC 19 service application, where the applicant must be a Malaysian citizen or company registered under the Malaysian law, besides limitation as to the scope of disputes under the schedule of COVID-19 Act. For those falling outside the purview of PMC 19, institutions such as the Malaysian Mediation Center and AIADR would come into play, where parties could resort by agreement to the respective processes and procedures on appointment and administration of mediation cases. It is an undoubted fact that the resort to dispute prevention and settlement would gain traction not only in Malaysia but across the globe with the current scene of COVID-19 pandemic. The introduction of mediation rules by AIADR and the planning for capacity building are timelier than required. Incentives should be given to parties in resolving disputes amicably through mediation, and promotional activities or events on dispute settlement should be encouraged to raise awareness. In conclusion, I would like to state here that I sincerely hope to see more collaborative efforts amongst all entities to advocate the use of mediation and dispute prevention. I therefore take this opportunity to commend the co-organizers and supporting organizations for coming together in promoting the Mediation Forum without charges to benefit of community and public. I wish great success to the forum. Thank you. Assalamualaikum warahmatullahi wabarakatuh.